Hello students, this is lecture number 2 on IPC. In this lecture, we are going to discuss section number 1 and preamble of IPC. This is contained in chapter number 1, which is the introduction part of IPC. Preamble basically states the object of any statute, and the object of the statute is to provide a general penal code for India, which will provide such type of penal code for India which will be applicable to all the persons irrespective of their religions and irrespective of the states. What the preamble states: whereas it is expedient to provide a general penal code for India, it is enacted as follows. Okay, and what section number 1 states, it tells about the title of this code and extent of operation of this code, that where this code is applicable. And what is the title of this code? The act shall be called the Indian Penal Code, and shall extend to whole of India. Okay, it is applicable to the whole of India. But it is very important to note here that before 31st of October 2019, IPC was not applicable in Jammu and Kashmir. But now, under section 96 of the Jammu and Kashmir Reorganization Act 2019, the Indian Penal Code extends to the state of Jammu and Kashmir as well from 31st of October 2019. Before this 31st of October 2019, Ranbir Penal Code 1932 was applicable in the state of Jammu and Kashmir. Now let us discuss some commentary on preamble. The preamble states the object of any statute. The object of this code is to provide a general penal code for India. Although the object of this act as embodied in its preamble was to provide a general penal code for India, which will be applied to all the persons irrespective of their religion, but the act does not repeal the penal laws which were in force at the time of coming into force of the code. What was the reason why the Indian Penal Code do not repeal all the penal laws which were at that time into the force? What was the reason? This was so because the code does not contain all the offences, and it was possible that some offences might still have been left out of the code, which were not intended to be exempted from the penal consequences. So those penal offences which are not given in IPC but they are given in some special laws are to be treated by that special laws. For example, illegal possession of any drugs, illegal possession of any liquor, illegal possession of any psychotropic substances are dealt with by their special laws. So that law will be applicable for that penal offences. Okay, not the IPC. IPC provide the general penal code for India, in which many offences has been given, but if any offense is not given in IPC, that doesn't mean it will not be punished if some special law has been given for that. Okay, and what is the operation of the code? Where the Indian Penal Code will be applicable? The Indian Penal Code extends to all the territory of India, and the territory of India is defined by Article 1, Clause 3 of the Indian Constitution. The territory of India includes the territory of the states like Punjab, Haryana, Jammu and Kashmir, Maharashtra, these are some states. It will be applicable to all the territories of the state. Number B, the union territories which are specified in the first schedule of the constitution, like Delhi is a union territory, Chandigarh is a union territory, IPC is applicable to the union territories as well, and such other territories as may be acquired by India time to time. Okay, the territorial water of India, which is 12 nautical miles from the coastal point, that can be said to be the base point. The territorial water of India also forms part of the territory of India. Therefore, any offences committed within the territorial waters of India will also be deemed to have been committed within India. So this was something about this lecture. Thank you.